Hello and welcome to A.Zalesov and Partners Patent Law Firm channel, where we discuss Russian and Eurasian patent system. Today we would like to present on the Hague International Design Registration System and how to use it to obtain protection of your design in Russia. Russia joined Hague system since about 2 years, and by now we have some practice to share on the actual application of that system in the Russian Patent Office. And I would like to ask my colleague Maria Makhlina, who is a Russian and Eurasian design attorney, to share her views on Hague system and how it is to be used in Russia. Maria, please.
Thank you. So, dear sirs, I know that you are familiar with the Hague system, so just let me remind you some basic things that by filing a single application in one language and by payment of the unique set of fees, you can obtain protection in more than 90 countries, because there are 75 contracting parties, and recently Belarus has joined also, and it is possible to designate Belarus from 19th of July 2021. So Russian Federation has ratified the Hague Agreement by joining to the Geneva Act. So when ratifying, Russia has made several announcements concerning the requirements to the process, to the Hague system. So one of them is that they have individual fee, they have deferred publication. That is not possible, unfortunately, in Russian Federation, that the notification on grant starts only from the date when the International Bureau has been informed by the Russian Patent Office that the protection has been granted. Next one is that the notification of refusal is issued within 12 months, and also that there is a unity requirement. The next one is the general term is 5 years, but can be extended up to 25 years within the periods of 5 years each one, and the general term is not more than 25 years. And the next one is that whether you have changed the owner in your international registration, it would not have effect until you submitted the corresponding documents to the Russian Patent Office.
Okay, so these are the general rules, let's say, of the application of Hague system in Russia. And actually, what are the peculiarities our colleagues should know when applying to protection of their design in Russia through Hague system?
Yes, certainly, because first of all, Russia is conducting substantive examination. That is important.
Sure, yes.
Certainly, all the formal examination is conducted by the International Bureau, but Russian Federation is checking unity, is checking originality and novelty of your design submitted, and also is checking some principles of morality and protection of the official signs. And when you are going to designate Russian Federation and you are claiming earlier priority, you should know that it is mandatory to submit a certified copy of the priority document. And it can be submitted within 3 months from the publication date of your design.
So our colleagues should know that if you file through Hague in Russia, claiming an earlier priority, just start preparing your certified copy of the priority document, because you will asked to, within 3 months, to provide it to the Russian Patent Office, Patent. Yeah?
Yes, but unfortunately, Russian Patent Office would not notify the applicant, so you should bear it in mind. What else should we bear in mind when designating Russian Federation? So we do have strict unity criterion. Right. Yes, exactly. So whether you have up to 100 designs, unfortunately, in the Russian Federation, it is almost not possible to protect all these 100 within one application, because Russian Federation considers that whether there is a single creative idea, in this case only, the unity criterion is okay. So to what applications do we have this criterion? First, it's when there are variants. Variants are only differ with one non-essential feature or just in color. So this is okay. You can include such kind of variants in your application. And another one is it is a kit or a set that is claimed.
Okay.
Next one, yes.
So and it means that in any other situation, the applicant is going to receive objection on unity. So, yeah.
Exactly. So, a notification on refusal is issued by the Russian Patent Office whether your design or group of designs does not conform to the unity criterion.
Yeah. And what should be done in this situation?
So, first of all, whether you are okay that only one design will be considered, you can just not file a response to the Russian Patent Office, and in this case automatically the Russian Patent Office would consider the design or group of designs indicated first. Whether you would like to choose one of the designs or group of designs, you should notify the Russian Patent Office within 3 months what design should be considered. The next one, for example, you have received a refusal and what to do with your other designs.
Exactly. Yeah. If you need not just one, but more than one.
Certainly. There is a possibility to file the divisional application within 7 months from the date of refusal. But in case of divisional application, you should know that in this case, all the formal requirements...
So, let's stress, it means you're going to file a Russian national application, of course, claiming priority of your Hague registration, but it will be a new application file, I guess, with all formalities.
Yes, and here is when the problems come, because sometimes the certain features of your application, they just do not coincide with the requirements that are provided by the Russian Patent Office. For example, when you would like to indicate the parts which the applicant, the protection is sought. In this case, you are sometimes using it by highlighting with the color. And it is absolutely not possible for the Russian designs, because for the parts for which protection is not sought, you should use the dashed or dot lines. So this is a bit hard for the applicants, and in case of divisional applications, it is really hard. So please bear in mind that better to have your tips concerning how to overcome some when on the date of filing, what should be do. For example, in relation to drawings, in relation to drawings, provision of drawings, in relation to the unity, to not to have these obstacles when filing your application or filing divisional applications.
Okay, Maria, what you think about the substantive examination of Hague registration? Would you compare actually what is to be done over this part of the procedure? And basically, let's compare Hague registration and Russian national application, design application. So, what are the benefits, advantages, maybe disadvantages of each of these procedures? What would you recommend?
Exactly. Yeah? So, whether in relation to Hague registration, which is being considered in the Russian Patent Office, you will receive the refusal without any further possibility to explain to the examiner anything, to provide your response. Only in case of unity you can choose the one, or just not to provide a response.
So it's like a single action.
Yes, exactly.
If they don't see any novelty or originality, they just reject it.
Yes, exactly. So it's a refusal, and what can be done? Only you can appeal this Russian Patent Office decision to the special division of the Russian Patent Office. It's like a single administrative procedure. You are filing an opposition to the Chamber for Patent Disputes that is considering your grounds, and it also have oral proceedings.
So sort of litigation,
Exactly. So it's sort of litigation, and further it can be appealed, this decision, to the special court, intellectual property rights. But in case of the Russian procedure, and in case you have a complicated case, we would recommend filing a national Russian design application, because it's more convenient. When you have problems, you can first receive an office action and further provide, during this examination procedure, you can provide a response to the examiner with certain grounds, certain your arguments, and maybe you will receive your registration. And also the procedure is pretty smooth with its only one design, and you can explain the expert, the examiner.
Would you agree with me that if I summarize it this way, if you have a simple case, you suggest that it's a simple case, it's worthwhile to file through Hague because you don't need any formalities objection, and if everything is okay with novelty and originality and it's not unity, you believe that just one design matters, so you obtain your protection via Hague. But if it's a complicated case, but you need very much to have this design to be registered in Russia, so you enter a Russian market with this, let's say, with this stuff, then we would recommend to try to have Russian national application.
Exactly, yes, I would agree in this case. So,
and it will be even more cost effective, yeah?
Certainly,
yeah, because
procedure is really more expensive and complicated in the Chamber for Patent Disputes.
So, complicated procedure started with Hague registration would cost you more than a complicated procedure started with the Russian national application, just because during the Russian national design application procedure you would have possibilities to respond to the office action and explain your position in detail to the examiner, and quite often examiner changes his mind and provides you a patent. Meanwhile, in the Hague system you will be rejected, you will have to formally appeal against examiner in the Russian Chamber for Patent Disputes. Yes, we have such practice and we are success in several cases, but definitely it will cost you more.
Exactly, yes. So let's get back a bit to the refusals that the applicants are recently receiving. So sometimes they are connected with the non-compliance to patentability criterion originality. It is a bit complicated because originality is when the claimed design does not have the same general impression to the informed consumer as the one, for example, known already from the prior art. So, meaning that the design that is reflected on the set of images provided does not have the same general impression. When considering the application, the informed consumer will be the expert himself. Yeah. So this is a bit difficult because the expert decides whether the design has the same general impression.
So it's supposed to be quite subjective, yes.
And further, the proceedings of saving your design during the considerations in the Chamber of Patent Disputes, it's really complicated because you have to, sometimes the expert is participating on the hearings in the Chamber. Yes, and you have to persuade him that he was not right. And it's
but that's difficult. The bad part of the story. But do we have a good part of the story in the Russian legislation, like about the grace period?
Yes,
which can our colleagues enjoy? Yeah.
Our Russian Patent Office allows the disclosure of the design, and it would not affect the novelty in case the application is to be filed within 12 months from the date of such a disclosure. So
why is that important, by the way? So we just discussed that keeping priority sometimes is problematic, and if you just do not provide your priority application, you are losing priority, yes? And let's suggest that your first application is published, yeah? So, and you did not manage to claim correctly priority. But actually, this is a bad news, so you are losing priority 6 months earlier. But this is a bad news. But the good news is that your own publication is not going to be cited against your design in Russia because we have 12 months grace period. This is good news. Yeah. Okay. Yeah. So summarizing that, again, we are glad to inform you that Russia is a part of Hague International Design Registration System. It's a very convenient system, and it's a very convenient tool to our foreign colleagues to seek protection in Russia. But as everything in this world, it has some advantages and disadvantages, comparing it with the Russian national filing. And of course, we advise to consider both instruments in your practice and apply each of them where it is to be applied. Yeah?
Exactly. So just do not, you have to keep in mind that you need to submit priority document where the priority is claimed. You need to think about unity when filing and the single
right.
priority idea, and to think about strict substantive examination somehow. So, and then to decide what route to go, whether to file a national
That's right.
application or to go by the Hague system.
Okay.
Yeah.
Yeah.
I guess it's...
So, thank you very much for your attention. File in Russia, stay on our channel, please subscribe, and thank you again. Bye.
Thank you, goodbye.
Bye.